A decision is expected on April 19th in the case filed by the Guyana Teachers Union against the government of Guyana over the legality of the 23 days teacher strike. The case also dealt with whether teachers ought to be paid for the days they were out of the classroom. The court will also rule on the suspension of the collection of the union dues by the government and remitting the same to the Guyana Teachers Union. Attorney General Ani Nandalal made the closing submission this morning before Justice Sandel Kasoon, and he told reporters on the corridors of the court that he believed that the proceedings filed by the teachers union through their lawyers were defective. He posited wages are defined in the Labor Act as monies paid for work done or to be done. However, Senior Counsel Roysdale Ford, the teachers union lawyer, had a different view.
That is the definition of wages and salaries, for work done or to be done. So how can you not do work and expect to get paid? I also examined other parts of the Constitution which they relied upon to show that no international treaty that we have signed at the ILO or anywhere else has conferred a right on a worker to get paid for work not done during strike period. So that concept, I believe, I rejected completely. I dealt with the principles, although they were not pleaded, because they were raised in the arguments by the other side. I believe that I demonstrated with great clarity, examining the Constitution, the 1966 Constitution, the 1980 Constitution, the 2001 Constitution, and all the changes that have taken place in relation to trade unions and in relation to rights to strike and freedom to strike, that there is no right to strike in Guyana, there is a freedom to strike. That's an important thing. The Constitution has a right to demonstrate, a right to assemble, but a freedom to strike. So the draftsman using language differently, different language to portray a different concept. Then you have the rights of the worker, of the employer. The Constitution also protects the employer's right to property. So how can you advocate that you have a right to pay when you have not worked? Because if you are to be paid for service not rendered, then you are compelling the employer to give you his property for which he has received no compensation and no reward. So that's the first, constitutionally, the concept can't fly.
We articulate a position where we believe that the Constitution, Articles 147, 2 and 3, constitutionalize the right and freedom to strike. We also pointed out to the court that by virtue of Article 154A of the Constitution and Schedule 4 of the Constitution, the international convention, particularly the ones on civil and political and economic rights, specifically provide for a right to strike. So even if we accept the submissions of the Attorney General and state that Article 147 does not include the right to strike and it's just a freedom to strike, there's definitely statutory basis for saying that through the Constitution, which might not be a fundamental right, but because of its source coming from the Constitution, it is a constitutional right to have a right to strike. I believe that the implications of that were not contemplated by the Attorney General when he argued that simply there's just a freedom to strike. That is why he stood up towards the conclusion and pointed out to the court that there is a provision which provides for a right to strike. So whether we consider it a freedom to strike, a right to strike, I also pointed out that the Canadian authorities indicate that the constitutional fundamental right must be construed in accordance with the international convention.
The Guyana Teachers Union was represented by Senior Counsel Roysdale Ford and Darren Wade. Key witnesses in the matter were also cross-examined by both sides.
Today, the essence of my argument is established first that the principle of no work, no pay was inapplicable to Guyana. Secondly, to establish that the role and functioning of the Chief Labour Officer and the Minister of Labour aggravated the circumstances which led to the strike. We were able to present arguments in relation to those principal reasons. We were also able to deal with the question of the deduction of dues, which we articulated that was unconstitutional, and we believe that the court would have had sufficient information, sufficient arguments, that next Friday the court is likely to rule in our favor.
The arguments in relation to the right to strike I believe there are several legal authorities, as I did indicate it to the court, that are very instructive. There's a case of Quincy McEwen that you would have heard coming up very often. There's the case of Thomas, that is the young man who genitals was burned by the police, whereby Justice George said that judges has a duty to incorporate international principles, which was later adopted in the Quincy McEwen case. So that laid the foundation and the basis in relation to the right to strike. The judge asked me, I believe it was at the opening of my argument, was stressing what is the basis, and at the end, that's this way we ended up in relation to Quincy McEwen, Thomas cases, our constitution, and so forth in relation to that.
It took the court mediation process to end the prolonged strike action after the government refused to meet with the union.